He promised a new brave bar to restore what he termed as LSK's lost glory if elected the president of the Law Society of Kenya. More than a year later, he holds that office. But how brave has he made the bar? Tonight on Pundits Night, we speak to LSK President Nelson Havi. Good evening and welcome to the program. I am Abubakar Abdullahi. As always, your voice matters, so does your opinion counts as a viewer. Talk to us, send us a message on 22047. The hashtag to use is Pundits Night. Mr. President, good evening and thank you for making time for us tonight.
Good evening, Abubakar. Thank you for hosting me tonight.
All right. On the 27th of February 2020, you won the hotly contested LSK presidential LSK presidential position under your campaign mantra of a brave new bar promising to restore LSK's lost glory. Let's start from there, Mr. President. How much of LSK's lost glory has been restored a year and 3 months later?
Well, a player is the least placed individual to evaluate his performance. But when he's off the pitch, he may say what he has received from the spectators. We undertook to perform on the basis of 3 key point agenda. One was to monitor legislation. 2 was to protect the Constitution and the rule of law. And 3 was to expand the practice environment. Let's start with the monitoring legislation. Over the last 1 year and a few months, the Law Society has played a pivotal role ensuring that the laws that are enacted by Parliament are valid, they conform with the Constitution and benefit the public. I will just highlight 2 or 3 milestones. First and foremost, we managed to petition the Chief Justice successfully to advise the President of the Republic of Kenya to dissolve Parliament for failure to enact 2/3 gender-compliant rules and laws, and also for Parliament itself being non-compliant on that principle. Number 2, and which is the recent most milestone, is the assault we have waged against the attempt to effect a constitutional amendment through the famous BBI bill. So insofar as monitoring legislation, there are many things that we have done, but those 2 stand out. What about the rule of law and constitutionalism? We've been at the forefront of ensuring that decisions made by the executive conform with the Constitution and are made for the benefit of the public.
All right. All right, and many credit to you. I spoke to quite a number of lawyers before this show started. They talk of Nelson Havi being a brave LSK president. Credit to you where you so deserve. But there are equally those who point fingers at you for making the Law Society of Kenya a one-man rule-run show.
Well, there are those with impaired vision. There are those with the impaired hearing capacity. I will not blame them if that is their conclusion. But what is fundamental is, are we being felt as the premium bar? Are we involved in decision making in this country? Are we bringing change not only to advocates but to the entire Kenyan population? The popular view is, yes, that is the case. If you go to Nyeri and you say that you are a lawyer, the Mamamboga will tell you, oh, Adua Havi. You understand? If you go to a petrol station, I lower down my window and say, oh, President of the LSK, thank you for what you're doing.
Which is partly why some point fingers saying Havi is LSK and LSK is Havi.
Well, for good reason, because those who preceded...
Not entirely good reasons, Havi. We'll come to that a little bit later, though.
Yeah, so, you see, a leadership is defined substantially by he who is at the helm. But that does not mean I'm acting alone. And fundamentally, I must say, there are 4 of us who have been at the steering wheel of the progress that you're seeing. My very able Vice President Daudi Kamende, Council Member Herin Kabita, and Council Member Esther Ngawa. We work day and night to ensure that the agenda we set forth for the benefit of the lawyers and the people of Kenya is achieved.
So those who say it is a one-man run society, LSK, they're speaking from the vortex of uncertainty, you will say that?
No, the Law Society of Kenya is a corporate entity. It is inconceivable that it may be run by one individual. Let me give you one story. About 2 years ago, Ambrose Weda told me, the problem, Harvey, is that people fear you'll be a dictator. People fear that you will make decisions on your own. But their fear is unfounded because lawyers are well-informed individuals. You cannot take decisions unilaterally and expect them to stand. And the progress so far is testimony of that fact.
All right, and let's talk of that which some of your critics point to, which is a power struggle within the Law Society of Kenya. They cited last year's standoff surrounding the tenure of the CEO. You have, as a person, responded to that, saying that that person is no longer with the Law Society of Kenya and ceases to make statements to media houses of being the CEO of LSK.
There is no power struggle. The power I exercise is power that is given at the ballot. So that if there was anybody who was competing with me, with the people given power, then there will be validity in the claim that there's been power struggle. But yes, there's been tumult at the leadership of the Secretariat of the Law Society because the person who, until the 19th of October, was holding that office has been an impediment in an exercise that intended to audit the accounts of the society, and to a large extent has been the entry point of formation by forces outside the Law Society to interfere with our leadership. But that notwithstanding, we've been able to surmount all these hurdles and still perform as per the expectation of the members of the Law Society as well as the public. You say to interfere with the leadership. What mode or form was that interference on? Abu Bakar, I know you're not pretty old, but if you are to go back in the history of the Law Society, you'll realize that the Law Society played a very big role in the second liberation. And I will point to key figures who are the forefront of this struggle. First is the retired Chief Justice Willie Mutunga, Dr. Gibson Kamau Kuria, Honorable Paul Kibuge Mwite, and you saw the assaults that the government of the day undertook against the Law Society of Kenya then. If you were to look at history, what is the environment in which we're working right now? We're working in an environment where the rule of law and constitutionalism is something that is quite alien to those who are in office. There is determination to subvert the constitution. Court orders are not being obeyed. And you see, when you come out vocally, when you come out and demand that these issues have to be complied with, you're bound to receive resistance. And I'm not lamenting. If I was not performing optimally, then you wouldn't be experiencing this criticism that you've just referred to. There will be no need for the government to interfere with the premium bar.
All right, and I still will paraphrase my question probably. You talked of interference rather. You talked of how that interference is, which begs the question, who is interfering? When you say the government is a blanket judgment. You know that better than I do.
Well, Bakar, as I've said before, if we are demanding that judges be sworn in, the 40 judges, if we are saying that there is a court order that has directed the return of Kenya Meat Commission to the Ministry of Agriculture, there is a problem in the manner in which the Constitution is being amended. You are able to identify the individuals who hold the highest responsibility behind that resolve.
All right. And the individuals who are behind that are who?
Those with eyes will be able to see Abu Bakar.
And for those like me who don't want to assume things, you know them?
You will do some little reading and you'll be able to get to know who they are. I don't want your station.
Will that be fair? Will that be fair to conclude?
I don't want your station to be sued.
No, will that be fair to conclude?
Yes.
That you are citing interference from the executive or any other arm of the government?
Yes, that's what we've stated affirmatively.
All right. Nelson Havi, 3 years ago, one of my favorite writings you have put on paper comes of an opinion piece you wrote in one of the leading dailies.
Yes.
And I'll in part read what you said then. That the cartels are trembling and fear that their corruption deals in the corridors of justice are going to be terminated in totality. Their powerful strings of intellectual arrogance cut short, and that they are going to be unable to exercise further their dark centrifugal influence. First, who are those cartels? When you were writing that piece 3 years ago.
Which piece are you reading from? It's quite a while.
The title of that piece is Only Young Lawyers Will Free LSK from Decay.
I don't remember penning such a piece.
You don't remember?
No, I don't remember.
Are there cartels within the judiciary, as some observe?
Yes, there are cartels within the judiciary. They have been there for a considerable period of time. Many before me have pointed to the existence of these cartels. But it is our determination to ensure that the wheels of justice continue running smoothly and justice is delivered to all Kenyans.
All right. Well, as a viewer, you're watching Pundits Night. Keep talking to us. Your opinion matters. So does it count? Send us a message on 22047. Tonight, our guest, just a reminder, is the Law Society of Kenya President Nelson Havi. We have talked of the brave new bar. We have talked of the article, which of course the president said he does not remember. He has a right to say that. Havi, let's talk of the judiciary and the independence of the judiciary.
Yes.
Often when we hear of the independence of the judiciary or the independence of anything, there is often the linguistic term of independence as being free from something.
Yes.
What is the judiciary being free from?
Let's trace the journey of the judiciary hitherto. Before the promulgation of the Constitution on the 27th of August 2010, the judiciary was a department of the executive. Judges were directly appointed by the president by then what was the Judicial Service Commission that did not have an existence of its own as we have right now. But currently, the structure of the Judicial Service Commission, the entire setup of the judiciary is such that it comes into being without the intervention to a large extent of the executive or the judiciary, and permit me to say also of players that are in the private sector. The expectation therefore is judges will make their decisions on the basis of the facts and the law, and that the entire institution of the judiciary will not be under the direction of either the executive or parliament or other interested groups. To what extent has the independence of the judiciary been achieved? I think the developments have been enormous, but a few setbacks where decisions have been made that tend to tilt towards either the influence of private individuals or the influence of the executive. And that's expected in any democracy, but the balance has to be maintained. And often this balance will be maintained depending on the caliber of judges that are sent to office, depending on the vision of the head of the judiciary at that particular time. Also depending on the composition of the Judicial Service Commission and to what extent that commission aspires and lives to the aspiration of ensuring that the judges that are in office are of the quality desired to secure the outcomes beneficial to the people of Kenya.
And the judiciary is one arm of the government. Often people misconstrue and say it is the third arm. It is one arm of the government.
Yes.
We have talked of independence. There are those, and I'm sure you must have had this conversation, there are those who talk of interdependence.
Yes, because you see the three arms of government are like the traditional African stool. none can function without the other. The legislature, or parliament as popularly called, is the one that makes the laws. The executive is the one that implements the laws. Now, the judiciary is the one that is in charge of resolution of disputes between private individuals, or between private individuals and the state on the other hand. But it must be understood that the power given to the judiciary is delegate power, just as is the power that is given to the parliament. And
delegated by the people?
Yes, it's people-given power, so that it has to be exercised for the benefit of the people. Then there is the coercive aspect of judicial authority, the implementation of the decisions of the court. To a large extent, the courts depend on the goodwill of the executive to provide an enabling framework for enforcement of court orders, to provide finance to sustain the operations of the judiciary. So to that extent, there is interdependence amongst the three arms of government.
But there is no interdependence of goodwill, as some suggest, that the judiciary must be in line with what some other forms and arms of the government may want.
Well, perhaps you are tracing the history of that perceived goodwill to pronouncements made by individuals who hold high office in the executive, who say that if you do this, then we'll help you. If you don't do this, then don't expect us to help you. But the understanding emanating from the Constitution is this, that it is not a favor that is being done to the judiciary to ensure that the judiciary fund is enabled. It's not a favor that is being done to the judiciary for court orders to be obeyed by the executive, so that it's not quid pro quo, that you do this, I do that. It is an unqualified obligation of everybody, be it Abubakar, be it Nelson, be it Tony, to comply with the law. So that the so-called goodwill is a construct that has been coined by individuals who do not ascribe to good governance, the rule of law and constitutionalism.
All right, one of your manifestos was to monitor legislation. You talked about it earlier on.
Yes.
But some credit to you for that as well, on puncturing, for the lack of a better word, of the BBI bill and process, the declaration of the NMS as unconstitutional, a bar that saw the advisory of the dissolution of parliament. Let's talk of the puncturing of the BBI. The court 2 weeks ago made a ruling, a determination declaring it was illegal and unconstitutional. And some of the reasons the court decided that bench was that the doctrine of the basic structure of the Constitution cannot be changed.
Yes.
Is my explanation right to say that that doctrine supposes that there are elements and features within the Constitution that cannot be implemented?
Fundamentally, yes, because the Constitution of Kenya that was promulgated on the 27th of August was a product of a long struggle towards realizing good governance in Kenya. For instance, look at the manner of the executive. The president, unlike the situation before, is not an elected member of the National Assembly. And it's for good reason, so that the president can sit outside the National Assembly and implement his policy or her policy for his term. What about the cabinet? The cabinet is constituted of individuals who are not traditional politicians, technocrats, people who are not elected into the National Assembly. And the National Assembly, therefore, is supposed to play a role of ensuring that there is adequate distribution of the national resource. There is oversight over the executive, the manner in which administrative decisions are made, the manner in which appointments are made, the manner in which expenditure is incurred. Now, let's go also to the judiciary, as we talked about the issue of independence before. All these are setups that were not there before. They constitute the basic structure of the Kenyan Constitution. Now, when you want to bring a prefect of the executive and house him or her within the judiciary or the Judicial Service Commission, you are interfering with that structure. When you want to appoint cabinet ministers from the National Assembly, when you want to have an official leader of the opposition, when you have a prime minister and deputy prime minister. This is not what the people of Kenya wanted when they created the constitution in August 27th, 2010.
Mm-hmm.
So it is a concept that is accepted and understood in the Kenyan constitutional order.
And that concept, among other countries that it has been cited, is Uganda and India, of course. But where does that leave Article 256 and 257 of the Constitution that talk of ways of amending the Constitution, either through a parliamentary process or a popular initiative?
Now, there is a difference between amending the Constitution and dismembering the Constitution.
Mm-hmm.
To amend is to make better, to improve on that which is there without altering the entity
mm-hmm.
that you are amending. But what was being undertaken through the BBI bill was a destruction of what was there, because we had a prime minister not so long ago, about 10 years ago,
mm-hmm.
with ministers who had been appointed from the National Assembly. There is a reason why we moved from that setup to the setup that we have currently. So to take us back is dismembering. It's not amending.
I'm talking of that ruling which the bench made, saying that the BBI is unconstitutional.
Yes.
The promoters intend to appeal, and they have done so. As a lawyer, leave Nelson Havi, leave the president of the Law Society of Kenya, leave the man who was part of the team that petitioned what was consolidated into petitions. Is there a legal possibility of the appeal succeeding?
Well, who knows tomorrow? Whosoever goes to court to present this case
mm-hmm.
will always subject the outcome to the judges.
Mm-hmm.
And we lawyers are law-abiding individuals. However strong you feel your case is, the outcome of the court will prevail. But you are able to evaluate for yourself. The Kenyan people are able to see whether the enterprise that has been halted by the court in the name of BBI
mm-hmm.
was a constitutional moment, was a beneficial exercise to the people of Kenya. Is it really true that you cannot distribute national resources throughout the country equally without amending the Constitution?
Mm-hmm.
Is there an impediment in increasing the allocation to the counties? Is there an impediment in making appointments that take into account ethnicity and regional balance? You see, if you were to answer these questions, then mm-hmm. you're better informed to know where are we headed in the Court of Appeal. Where are we headed should the matter proceed to the Supreme Court?
And you have quite preempted my question, which is, if the promoters decide not to go to the Court of Appeal, not to seek a stay from the High Court, and go directly to the Supreme Court, will that be a show of any significance, case of partiality or the lack of it?
Well, the set of facts as we have right now, Abu Bakr, are this.
Mm-hmm.
The application that had been filed before the High Court by the Attorney General on behalf of the executive, if I may say, was withdrawn.
Mm-hmm.
There are currently 3 applications before the Court of Appeal. One by the Attorney General, another one by the IEBC, and another one by Raila Odinga and the BBI Steering Committee. Mm-hmm. They all seek to stay the decision that was made by the court on the 13th of May. So it's not in the realm of conjecture as to where they have taken their claim. Their claim is now in the Court of Appeal. We expect that the Court of Appeal will give directions, and we also expect that those 3 individuals will serve their so-called applications and stop arguing them in the newspapers without affording us an opportunity of seeing exactly what it is that they have lodged before the Court of Appeal. Because we've only read of this application in the newspapers. We haven't been served.
All right, and we are talking of the state of the judiciary. Kenya's judiciary today saw the official taking over of office by the first female chief justice in the country. What do you foresee the Koome court will be, predictably?
Well, first and foremost, I've appeared before Justice Koome for the last about 17 years. I mean, it never occurred to me that when I appear before the court is female or male. So there is nothing really monumental in the gender of the individual who was ascended to office as Chief Justice. But what is fundamental is this. The best time to evaluate the performance of the Chief Justice is perhaps maybe after 6 months, 1 year, or thereafter. Because right now there's a lot of celebration. The issues that could have lingered have been put in abeyance with the expectation that, and I may quote the words of Aden Duale in Parliament, with the expectation that the Chief Justice will leave to the oath of office that she has taken. She will not bend to the whim of the executive. She will not be biased. She will not be influenced by issues outside the facts of the case, the decision-making capability of the Chief Justice. But more fundamentally, let me quote what the Chief Justice Emeritus, David Maraga, told the Chief Justice today, that constitutionalism connotes constrained power, limitations, and that is the essence of rule of law and good governance. And to add on to that, let me also quote what the Deputy Chief Justice told her. She told her that I will assist you in every lawful enterprise that you may ask me to assist you in. And henceforth, you are not the female Chief Justice, you are the Chief Justice of the Republic of Kenya. So let's debunk this myth of first female Chief Justice. To me, it's not of great concern. What is of great concern to us is this. We need the 40 judges sworn in. We need the judiciary fund effectuated and implemented. We need court orders to be obeyed. We need certainty in the manner in which judges are making decisions, so that they do not calibrate their decisions to lean towards a particular angle. And the good Chief Justice proceeds from a premise of a lot of suspicion that she's perceived to bend towards the executive. But it is an opportune moment for her to perform in the manner in which she has promised, so that when we evaluate her performance 6 months from now, 1 year from now, we're able to say these are what the Chief Justice promised, and we're able to see so far, so good, so far, this requires improvement.
All right, you say of 6 months, 1 year period to evaluate. What informed the decision through a memorandum dated 29th of March, which to the JSC, the LSK said that she was not fit and suitable to succeed David Maraga as the apex court? What informed that decision, Nelson?
The memorandum was informed by facts which were presented before the Judicial Service Commission. And if you remember, those facts were put before the Chief Justice. Those facts were also deliberated by the National Assembly. But what is fundamental is what the National Assembly said. I believe it must have been through Kimani Chingwa, the member for Kikuyu, and Aden Duale. They said, well, they do not know why the Judicial Service Commission did not consider these issues to be fundamental, but nonetheless, it is the expectation that those issues that have been raised against the Chief Justice will be issues that will be put aside, and that the Chief Justice will perform in a manner to indicate that the concerns raised are concerns that will not affect her performance.
All right, Nelson, we have talked of the state of the judiciary, we have talked of the Law Society of Kenya. I bet we can now talk of Nelson Havi, either the already politician or the prospective politician. First, is it the case that you want to be Westland's lawmaker in the 2022 polls?
Yes, I will be retiring from office as President of the Law Society of Kenya on the 24th of March 2022. And I have expressed interest to serve in the National Assembly, in particular for the people of Westlands. Of course, this is in tandem with my initial 3-point agenda, monitoring legislation and ensuring that there is the rule of law and constitutionalism because you will realize that there is very little that you can do as an individual through the court process. Take, for instance, the manner in which laws are being enacted in Parliament, the distribution of the national revenue, oversight. What is the problem? How is it that 5 Kenyans are able to see a problem in the BBI bill, yet hundreds of elected members are not able to see it? Perhaps it's time that the Kenyan people considered individuals with the abilities as the ones I believe I profess to serve in the National Assembly wholeheartedly, and not to do that which we always hear happens in Parliament, that the retreat to toilets to be given 20,000 shillings. So allegedly. Yes, that's why I said what we are told.
Okay.
You understand? We need individuals who can stand for something. And so far, my track record demonstrates my ability to do that. And I believe given the opportunity, we should be able to better the quality of legislation, the level of oversight, and the manner of general representation for the people of Westlands.
At least as per the pictures we saw and the communication from the ANC party, ANC is your party of choice.
Yes, ANC is the party of choice, and it's for that reason that I have associated myself with the party of choice.
And what makes it your party of choice?
It is the People's Party. You know, when you want to serve, it is not entirely a decision. You need to follow and you need to resonate with the heartbeat of the people. A majority of the voters in Westlands ascribe to the ideal of good governance, which they believe is available in NC through the party leader, the prospective future President of the Republic of Kenya, Musalia Mudavadi.
All right, and that constituency has a little more than 150,000 voters.